Welcome to the Fourth Circuit. We're ready to hear argument in our first case, Wills versus Pissus. I'm not going to try that one. Mr. Cooper?
Yes, Your Honor. I believe it's Solkowski.
All right, thank you.
May it please the court, my name is Jeremy Cooper. I represent Johnny Franklin Wills, who is incarcerated on a life recidivist sentence in Northern Correctional Facility in Moundsville, West Virginia. Several different occasions, the Supreme Court has held that it is unconstitutionally vague to increase an individual's criminal liability based on the standard that the crime presents a serious potential risk of physical injury to another. Mr. Wills' criminal liability was increased from the 1 to 10 year sentence that is the statutory sentence for larceny, grand larceny in West Virginia, up to a 15 to life sentence based on the standard that there was threatened violence to the person involved in his crime. That's based upon the proportionality standard announced by the West Virginia Supreme Court in cases dating back to the 80s, late 70s, that period.
Just to clarify, the statute itself increased the sentence, right? And the statute just requires 3 felonies, is that right? And then the potentially vague standard could possibly reduce that sentence, right? In your client's case, it didn't. But it's not the vague standard that increased it, technically.
Well, I agree with you that the statutory text allows the imposition of a life sentence after 3 felonies. It doesn't differentiate the types of felonies, the type of showing that has to be made about what types of conduct took place. It's just 3 felonies. Functionally, however, for the entire time essentially that Mr. Wills has been alive, if you are convicted of 3 felonies and a recidivist information is filed against you, then that analysis has to be undertaken.
Well, but to follow that question, the Johnson-DeMaya uncertainty language comes from West Virginia Supreme Court expressions. I'm reading one now, West Virginia versus Housden, which used the terminology, whether the nature of the crime involves the potential for threatened harm or violence. So that apparent allusion both to a categorical approach and an imprecise standard is from a state judicial decision.
Yes, absolutely.
That's not in the statute.
It's not in the statute.
I mean, that is the rule of law in West Virginia, but it comes from the statute. And I think that goes perhaps to the key issue in your case as to whether or not a judicial imprimatur that creates void for vagueness is one that's recently recognized for habeas purposes.
Yes, Your Honor. So the question, as you've discussed, is whether or not this standard, because it was announced by a court as opposed to a legislature, can be judged on the same standard that pure legislation would be. I think that if the West Virginia legislature had passed this law, it would be a pretty straightforward claim. It is obviously muddied by the fact that it was the Supreme Court that announced it rather than the legislature. But in Bowie versus City of Columbia, the Supreme Court held that the due process interest to notice that's protected by the 14th Amendment cannot be violated by any branch of government, including the judicial branch. And in that case, of course, the question was whether the modification of a very straightforward trespassing statute to encompass conduct that wasn't foreseeable, essentially based upon the plain language of the statute, could be retroactively applied to the first person who violated it. And the court held that it could not. But that notice interest does not just apply to the retroactive application of criminal laws. It applies also it is the origin of the vagueness standard, as well as the rule of lenity, as discussed in Linear.
Well, these may all be connected, but I thought in Beckles, the court said the void for vagueness inquiry is distinct from the ex post facto inquiry. They all may have notice principles at their heart, but they're slightly, at a minimum, slightly different inquiries. And the question for us on habeas is whether it was clearly established that this void for vagueness doctrine applies to judicial decisions.
Your Honor,
What's the opinion where any court has held that the void for vagueness doctrine applies to judicial decisions?
Your Honor, as far as I know, there is not an opinion that specifically states that, but there are two opinions which read in conjunction. You've got the Bowie opinion that talks about the retroactive application. If you look at United States versus Lanier, which discusses the different manifestations of that right to notice, then I think it's clear that the 14th Amendment right, which is not permitted to be violated by any branch of government, also applies in this circumstance, and not simply to a retroactive application. It's the same.
And it might apply. You might be right that there are reasons to think that this doctrine should apply or does apply to judicial opinions, but the question for us is whether it was already clearly established that it does when the West Virginia court acted.
Well, I think the standard also looks at whether or not the court unreasonably declined to extend a principle when it should have. And I believe, that's another frame with which you can look at this. Again, obviously, I think if it was legislation.
And so that, at what point in time do you say this failure to extend occurred? Was it at the habeas review by the West Virginia Supreme Court, or in the U.S. District Court, or both?
Well, no, it would be by the state court. It was the failure of the state court to extend the principle announced by the United States Supreme Court in this context.
And that's when they were reviewing the denial of his habeas petition from the West Virginia Circuit Court.
State habeas, yes, Your Honor.
Mr. Cooper, but how did they unreasonably apply it then? What did they fail to consider based on the Constitution?
They failed to consider whether or not this, and in fact did not even discuss, if you look at the state Supreme Court opinion, whether or not this falls into the due process right to notice that's protected by the 14th Amendment, as discussed in the two Supreme Court opinions that I've talked about so far here, the Bowie and Lanier.
Well, I think our standard, though, as I understand it in that circumstance, perhaps I'm mistaken, is that even if the state's House Court doesn't discuss the particular issue that requires a showing for habeas relief, that there could have been no rational basis upon which they based their decision.
Sure.
Is that accurate?
Yes, I believe that's accurate. I'm not going to contest that that the mere fact that they didn't directly address that issue that I'd raised in the state habeas appeal is dispositive. I'm not suggesting that in itself is dispositive. So I think the court is permitted to consider that. But I think it's interesting, again, that subsequent to these proceedings happening, the West Virginia legislature went back and actually modified the recidivist statute. Did not explicitly state in the preamble of the legislation that it was for the purpose of making it comply with these principles. But certainly, under the new version of the statute, every criminal violation that can be the basis for a recidivist enhancement is specifically described. And of course, that complies with the new law. And I think that is a recognition that there are constitutional infirmities with the existing setup, which was a combination of the old recidivist statute interpreted through the proportionality standard. Going forward, I think the recidivist cases in West Virginia are unlikely to be affected very often, if at all, by this proportionality standard. But for the ones that took place prior to the amendment, I think there is this constitutional question that is I think, if it has not been stated explicitly, but the principle has been stated explicitly, that you have a 14th Amendment right to notice that needs to be observed by not just the legislature, but the judicial branch. This court, in 1975, prior to a lot of the cases that arose in West Virginia, including the housing case, held in Griffin v. Warden, that the recidivist statute should apply in situations that involve the potentiality of violence and danger to life. And that language was also adopted by the state Supreme Court, which again goes to show that it's not the actual conduct, it's not the specific elements of the offense, which have been held to be permissible bases to enhance a sentence, as in the ACCA. The elements test remains, and Justice Gorsuch discussed the potential availability of looking at the actual facts of the case. But you have just the potentiality of violence is the same, requires the same sort of ordinary case hypothetical that was found to be impermissible. And of course, in the facts of this case, as examined by the state Supreme Court, and on direct appeal, it was noted that the petitioner, who is only convicted of larceny, along with another person, went to the house. The other co-defendant was convicted of burglarizing the house as well. There was no suggestion that there was any person present who suffered violence, that there was any actual threat of violence made to that person. It was only the application of this hypothetical. And that is clearly a...
So is it your view that West Virginia uses a categorical approach here or a fact-specific approach, or do they just kind of take what hits them at the time?
Well, I think going back, again, starting with those cases in the early 80s that quoted from this court's Griffin v. Warden case, they were definitely using that modified categorical approach that was found to be impermissible in the Johnson line of cases. I think more recently, as I think the respondent cited in the response brief, there are cases that I think look more fact-specifically at the case, perhaps in light of that line of cases and trying to avoid any sort of constitutional issue with them. But in this case, certainly the court did not look directly at the facts of the case and determine that there violence took place or that there was any threat of violence. They looked at an entirely different hypothetical situation that didn't take place and judged that under that other hypothetical scenario, somebody might have been threatened with violence, which again is the exact type of hypotheticals that were found to constitute a vague conviction or a vague basis for enhancing criminal liability in Johnson and the succeeding cases.
Mr. Cooper, but let me make sure I understand your response to the question. Judge Agee asked, though, whether or not in this case the Supreme Court used a categorical approach or a case-specific approach. Your answer is what?
Categorical.
All right, but in your briefs, you do suggest, though, that they in fact did do a case-specific approach. And in essence, you just disagree with the conclusion they reached.
Your Honor, they examined the facts of the case. That is true. But
so if they're examining the facts of the case, is that not a case-specific approach?
It would have been if they actually relied on the facts of the case.
Well, but isn't that the essence of my question? What you're saying is they did it, but I don't like the result that they reached.
If they had analyzed the facts of the case and found that, in fact, Mr. Wills had employed violence or threatened violence, or there's somebody there who could have experienced violence, then I don't think that I would have any ability to take any qualms with that case-specific analysis. But here, that's not what happened. They looked at the case, and despite finding that there was nobody who could have been the recipient of violence, they determined that because it was a larceny that had a side crime by a co-defendant of burglary, that there might have been a possibility of violence taking place, which again is the kind of hypothesizing that is frowned upon in the Johnson line of cases. You're not talking about what actually happened, you're talking about what could have happened based on the commission of this particular crime. And that's what violates the vagueness standard. If there was a person there who had been victimized, who actually suffered violence, of course, or there was a potential for violence based on the actual events that transpired, then I don't think that I really have a lot to work with in that regard. But that's not what happened there was no violence, there was no person present, and under that standard, you have to come to the conclusion that the court employed the categorical approach, the potentiality of violence and danger to life as suggested by this court in the Griffin case in 1975, potentiality, not what actually happened, because it isn't what actually happened. So for that reason, I don't think that you can draw the conclusion that it was fact-based.
All right, thank you very much. You've got some time left on rebuttal. Ms. C., we'll hear from you.
Thank you, Your Honors, and may it please the Court. Lindsay C. here today on behalf of Superintendent Zilkowski. On his 10th felony conviction, Mr. Wills was sentenced under a West Virginia statute that everyone here agrees is perfectly clear, but he claims is entitled to habeas relief because the standard that the state Supreme Court uses to apply state court proportionality principles is unconstitutionally vague. AEDPA brings that argument.
Let's change the factual setting here a little bit and see if we can arrive at our distinguishing principles. So let's say Mr. Wills has just been convicted, same charges in the circuit court. He appeals, direct appeal to the West Virginia Supreme Court. They render an opinion substantially similar to what they did here on his habeas appeal. And then he appeals directly to the United States Supreme Court, raises a constitutional issue. Is there a different result there?
There's not a different result, but the analysis is different because that would be different. We wouldn't be under the AEDPA standard where the question would be, is the rule in fact already clearly established? It would be a different sort of question there. Of course, we don't have that. Here we do not have that Supreme Court decision. But the result wouldn't be different because showing the rule is clearly established is only the first hurdle that Mr. Wills has to clear. He has to show that he would win under that rule, even if these vagueness principles applied to a circumstance of a judicial limiting principle that limits potential criminal exposure. He still couldn't show he wins because he, in fact, had notice of the standards that would apply to him, and those standards are not vague under the principles that the Supreme Court has set forth. But I think it is important to make sure that we are looking at the right legal framework here. He's not in that direct appeal posture. He is in AEDPA.
You're correct about that we're under AEDPA here. I just wonder if in the hypothetical where we weren't, so follow me there, that what we were just talking about with your friend on the other side about whether West Virginia applies a categorical approach or not, and they seem to have acknowledged that the categorical approach and the fact-specific approach are different, that both exist, and that they have refused to pick a side, right? They have an opinion where they say whether we choose one or the other, it doesn't matter in this case, so we're not going to choose. Doesn't that make it more vague? I mean, for the defendant who falls under the statute and who's left wondering, which approach is the West Virginia Supreme Court going to pick this time? How will it apply to my case? Kind of impossible to know. If we weren't under an AEDPA standard, would that indeterminacy make it more vague, or is that not a problem?
I do think that it would make it a slightly stronger case for Mr. Wills. I'm not going to contest that. I would contest the premise there. It is true the West Virginia Supreme Court of Appeals has not clearly said we never apply a categorical approach, but in that case it's the Mahler decision, or if not, a similar one that said something like that. The court did in fact look at the particular facts of that case. It was domestic battery, and the court was recognizing we know there is this debate, and the defendant had argued that we should not apply a categorical approach, and the court said we don't have to give an answer here because domestic battery by its nature involves violence, but more specifically this crime here under the facts involve violence to a victim. And that principle of looking to the facts in each case is what the West Virginia Supreme Court of Appeals has done consistently. We can even see that from the cases that Mr. Wills cites in his brief. The Housden case, for instance, that talks about grand larceny and burglary, looks at the particular facts of that case and the potential for harm to a victim.
But they also, in the language I read to your counsel on the other side, used phrases that seem very similar to the DeMaya Johnson type phrases, because they talk about the nature of the crime involves the potential for threatened harm or violence. And some of those terms appear in the statutes in the Johnson line of cases. So it sort of seems like that the crucial defining factor here is the AEDPA standard.
I do agree, and let me be very clear. I think the AEDPA standard resolves this case. At best, there is an unresolved and interesting question how far these vagueness doctrines should go to limiting constructions. It is not resolved, therefore, Mr. Wills' petition should be denied. But if we are operating in this framework where we would look at, is this in fact a valid vagueness claim, I think it would still fail. Even under that language, Judge Agee, that you're looking at, the court did then go on to look at the particular facts of the burglary and larceny in that case. And that's very consistent with what the state Supreme Court does. But even if the court doesn't want to take a side on that, assuming, again, we get to the merits of the vagueness claim, there are other reasons that the Johnson and DiMaio line of cases would not apply here. Actually, Johnson went out of its way to say that any of those factors, and categorical versus case-specific is one of them, any of them in isolation would not necessarily be a problem. It was the constellation of really four things that found that the Supreme Court relied on to conclude that that statute was unconstitutionally vague. It was that categorical approach. It was also a standard that had an indefinite risk assessment. What does a serious risk or a substantial risk look like? In Johnson in particular, the statute also tied that to other crimes, and so it was really difficult to assess an ordinary case of arson or a crime involving explosive against an ordinary case of felon in possession. And then the last factor was that the Supreme Court had tried and failed many times to bring order and some kind of consistency to this area of the doctrine. We just don't have that here. Again, the West Virginia Supreme Court is looking at case-specific factors. That's true in this particular case here. We can look at that both at the direct review of the sentencing and again at the state habeas proceeding. There, the court looked at the grand larceny, which was the final conviction in this case, and said under the facts of this case, the victim in fact could have come home. This is what both the trial court and the state Supreme Court said, and there would have been that risk of threat of violence. In that case, there had been 45 minutes since the security cameras were cut and when the victim returned. So it's different from saying that in a hypothetical grand larceny case, somebody might return and there might be violence. That's different from saying in this grand larceny case, there was a very real potential for harm. So the state Supreme Court did do that case-specific analysis. It also did that on the other underlying third offense DUI charges. There, the court did rely on its previous Appleby decision, which is fairly close to, in all cases, DUI has the potential for violence, which makes sense because that's the reason we criminalize that. It's a reckless disregard for human life when you operate a motor vehicle while you're impaired. But even in this case, the court didn't stop with Appleby. It said this isn't a case of one DUI, therefore it's automatically categorically violent. So this is a case of 3 third offense DUI, so at least 6 separate DUI convictions. So that showed that this particular defendant had a repeated disregard. So we see that fact-specific analysis here. The other thing I would say that distinguishes this from the Johnson and DiMaio line of cases, this isn't an area where courts have really been struggling with how to apply this area of the law. For 40 years since the Wand Street decision, the state Supreme Court has been able to fairly apply a violence or threat of violence standard. This isn't the sort of thing we saw in the Johnson and DiMaio cases where courts were reaching contradictory resolve. In fact, the Hoyle decision, which Mr. Wills argues changed the law in some ways in 2019, it's actually an example of a very quick course correction in the state law. There had been 2 prior decisions that year that had reached what looked like opposite results when it came to drug charges. The state Supreme Court was very responsive to that and said, when the Hoyle decision came up, it's important for us to clarify what the rules are so everyone has notice going forward. So even the one instance where you could argue that there was some confusion in the law, the state Supreme Court corrected that quickly, and there hasn't been these issues lately that we had in the Johnson and DiMaio cases.
So if we were to determine that there had been no clearly established law that judicial interpretations in the void for vagueness area are a reasonable extension of established Supreme Court law, can we simply stop there?
We would not disagree. Yes, because the task for Mr. Wills is to show that it was unreasonable to apply existing Supreme Court precedent to this context. That's all the court needs to do. The court does not need to go further on what the law should be or might become in future cases. What matters here is that the law is not clearly established to say that a judicial interpretation at all triggers this sort of void for vagueness analysis. and certainly not a judicial interpretation in this context where it serves to lessen potential criminal exposure, not expand it. I think we can briefly look at the Bowie decision that Mr. Wills relies on to show why, in fact, that's the case. There, it is true, the Supreme Court was dealing with the judicial construction, but it really focused on three factors that show just how different it is from this context. The first factor was this idea of the judicial construction was enlarging criminal liability. That's all over the Bowie decision. The Supreme Court was really concerned with the idea that conduct that was perfectly innocent in 1960 somehow became illegal in a 1961 state interpretation of the statute. So the idea of transforming conduct into criminal conduct is something the court was very concerned about and isn't present here. The second distinction, the court was really concerned about unforeseeable developments. In that case, the state Supreme Court had been applying the criminal trespass law consistently for 95 years in one direction. So it was a complete surprise that they were going to change course in 1961. Here, as we've already said, that's the opposite. We have a situation of 4 decades of very stable application, and nothing that we've seen in this case or in the Hoyle decision before changed that. And the last distinction is one that Judge Rushing, you seized on, this idea the court was really concerned with the idea of the ex post facto concerns. The idea was that the conduct had occurred 1 year and the state Supreme Court decision didn't come down until a year later. And so the court said, of course, if the legislature passed a statute a year later, we couldn't apply that retroactively to someone. You can't do the same thing with a state judicial opinion. So it was really bound up with this retroactivity concern. There just aren't any cases from the Supreme Court that say when you don't have that retroactivity concern, that judicial constructions of any stripe are enough to implicate void for vagueness concerns. And certainly not enough to say judicial constructions that limit exposure are enough there. I think the last thing I note on that retroactivity point is there's really no argument that that exists here. Mr. Wills, in fact, was on notice of the standards that would apply to his criminal conviction. Of course, everyone agrees the statute itself is clear. Nobody is challenging that. But this also isn't a case of edge felonies. This isn't, a fraudulent check, which was in the Juan Street decision. This is grand larceny and DUI, which may not always involve violence, but it doesn't surprise everyone that those are the sort of things that may, in fact, commonly involve violence. And in fact, he also admitted at his sentencing hearing that he knew that the West Virginia Supreme Court treated third offense DUIs as violent crimes. That's something that the sentencing judge specifically asked him, and that exchange is on page 89 of the joint appendix. Are you aware that these prior offenses are something our court considers violent, and that the result is you will very likely be sentenced under the recidivist statute? And he admitted that, yes, he had that knowledge. So this isn't a case where he was trapped, even if, a potential objective other defendant wouldn't have been. He, in fact, had notice of the standards that would apply to him. So this isn't a case where we've got any retroactive concerns there. The only other potential retroactive argument would be that the Hoyle decision in 2019 somehow changed things by adding a substantial effect on the victim prong. But that standard was never applied to Mr. Wills. That decision came down 2 years after his original sentence was imposed and was reviewed on direct review. The trial court and the state Supreme Court looked at the well-established violence or threat of violence standard. The only decision from the state court that came down after the Hoyle decision was the state habeas decision. And there the court just cites the new standard, which has the three prongs instead of 2 prongs, but it refers back to the analysis from direct review. So he doesn't even have an argument if there was a change in the law that it was applied against him. So AEDPA does begin and end this. There is no clearly established rule that shows he's entitled to relief. And even if the court were to disagree on that, he would still have to show that he wins under that rule. And he can't do that when he, in fact, had notice and the standards, in fact, are not vague. There's nothing impermissible or unconstitutional about risk assessments. Johnson went out of its way to say that substantial risk, threat of harm, those sort of things are fine as long as they're not paired with the categorical approach and the tricky history and the tricky examples. If you don't have all of those, we don't have to throw out something just because it is not the most precise standard. And the last thing I'd emphasize is that's particularly important in a context like proportionality review that is not going to have clear, bright line rules all the time. The federal Supreme Court proportionality review looks at a lot of factors that could be argued to be subjective. It's a different sort of analysis than when it comes to looking at a particular statutory triggering offense. And what we have here is actually a very clear standard, unusual there. 2 out of 3 offenses have to meet one of 3 prongs. So we have a lot of clarity in an area where clarity is particularly difficult. It's certainly not enough to reach the very high approach for void for vagueness claims to say that it's utterly standardless in West Virginia. We have a standard, it's been working well, Mr. Wills was fully aware of it, and there's no reason to grant his habeas relief. Thank you, Your Honors.
Thank you very much. Mr. Cooper, you've got some rebuttal time left.
I would going back to the State versus Houston. It was talked about, looked at the specific facts of the case. That is, in fact, if you examine that case, very similar to Mr. Will's situation, where again, the court looked at the situation. There wasn't any actual violence that took place. There wasn't an actual threat of violence that happened to any individual person. But instead, the court determined that somebody could have, and I guess in an alternate universe, come home and been threatened with violence. Of course, that did not happen. Under the actual facts of Houston, as in under the actual facts of Mr. Will's case, there was nobody that came back and was threatened with or experienced violence as a result of the, in that case, breaking and entering. So, I think that, again, it's indicative of substituting the theoretical harm that could arise under this crime for the actual facts that took place in the case, and can't escape scrutiny based upon that. I'd also like to discuss the issue concerning the two inconsistent cases that preceded the Hoyle decision. In one of those cases, the state Supreme Court held that it did involve a threat of violence to the person to deal heroin. It did not involve a threat of violence to the person to deal pill-formed opiate drugs, despite the chemical similarity of the two substances. And of course, that preceded both the Hoyle case subsequently and preceded the change by the legislature going to specific enumerated crimes that can lead to recidivist treatment. That inconsistency has not been fixed exactly. I would note that the person who was convicted of selling heroin is in fact still serving a life recidivist sentence. So it's not that the court has gone back and fixed the inconsistency there and applied it in some sort of fair way. I think those two cases are very indicative of the ad hoc method that is completely unpredictable for criminal defendants, and it's not something that I think comports with the protections of due process, which exist and have existed for a very long time, and are certainly clearly established. The right to notice is not some recent invention that postdates Mr. Will's conviction. This is something that has existed in our law, has existed in the law which we inherited long before even the Constitution of the 14th Amendment were ratified. So that right to notice exists. It was violated by the manner in which the court sentenced Mr. Wills to life, even in the absence of a specific case that dealt with the exact same set of circumstances on which this court could rely. I do not have a case where this exact same thing has happened that I can point to the court, but I can certainly point that this right exists and the recognition that the right to notice cannot be violated by any of the branches of government. So on that basis, I would ask the court to find that it was unreasonable for the state Supreme Court to decline to establish the principle from Johnson and DeMaya to a factual circumstance that almost certainly wouldn't pass muster if it had been pure legislation, and that the court determined that Mr. Will's confinement on a life sentence violates his rights under the U.S. Constitution and grant him relief. Thank you.
All right, thank you very much. We appreciate the argument from both counsel, and now we'll come down in person to greet you, and we'll go on to our second case. Versus Risk-Based Security, Inc. Mr. Samuels, we'll hear from you.
May it please the court, this case is moot. Synopsys said in its complaint that its trade secret claims were about whether RBS had trade secrets in its VulnDB database and whether Synopsys misappropriated those trade secrets in its role as a CNA. That's that public non-commercial role we've been talking about. RBS then gave Synopsys a covenant not to sue that covered any and all existing or future claims based on Synopsys's role as a CNA related to VulnDB. So all the trade secret allegations in the complaint are covered by the covenant not to sue. Any other trade secret issues between the parties belong in Massachusetts State Court, and this case never should have reached summary judgment.
Was that covenant unconditional and irrevocable?
It was unconditional and irrevocable. It says at JA 581 that it's meant to conclusively resolve the litigation, that again, it applies to any and all existing or future claims, and so it is unconditional and irrevocable.
How does that language make it irrevocable again?
Because it's conclusively ending the litigation. It couldn't be, if you're conclusively ending the litigation, then you can't revoke it.
Your friend on the other side, I think, said it's based on a characterization of their position that's not correct.
A couple issues with that. One, it's based on what the other side calls a characterization of a position that's not correct, is actually just a defined term. So we go through some whereas clauses and we identify by ECF number things that the other side said. And then there's a defined term that calls them these non-use representations. I think that's what Your Honor's asking about. And then we reference those representations again, and then we get to the actual covenant not to sue language, which says this applies to any and all existing or future claims. But what they're really taking issue with is a defined term that we use to capture things that we cited specifically by docket number in the covenant not to sue. The other issue with their position is, as I just mentioned, what we're talking about are whereas clauses in a covenant not to sue. I think there would be a lot of transactional lawyers who would be surprised to hear that a whereas clause is now a condition or some method of revoking a written document. These are whereas clauses setting up the context and background of the covenant not to sue.
But your covenant not to sue is dependent on the existence of the whereas clauses.
It's not dependent on the existence of the whereas clauses. The whereas clauses set up the factual context in which the covenant arises.
Well, I mean, it's based on the factual context, and you're not releasing things that are not in that factual context, are you?
Well, the things that we are releasing and the things that are clearly within the factual context are everything in the complaint. Everything in the complaint. Synopsys has had several chances in the district court and in this court to try and explain what is it that this covenant doesn't cover. And by the way, even when Synopsys is calling the covenant conditional and revocable, when they try to explain why, they come up with only one example of what this covenant they say doesn't cover. And it's this idea of these associated BDSA records that we're talking about in the briefs. And so the idea there is that even though this case is about Synopsys's role as a CNA, which is that public disclosure role, you're disclosing software vulnerability information to the public, Synopsys says, well, after we disclose it to the public as a CNA, we make a note of it in this BDSA product, this private commercial subscribers only product. We make a note of it there. By the way, they make a note in BDSA of other vulnerability information too that doesn't come from them. The Synopsys CNA stuff is just the house brand, but they say we make a note of this in BDSA.
What about the declarations that are in the complaint that say they ask for a finding that Synopsys does not infringe any copyright held by RBS, has not copied or misappropriated any of RBS's intellectual property, has not violated federal or Virginia law, and has not tortiously interfered with any contract or business expectancy under Virginia law. Those aren't limited to the CNA.
What they are limited to, or what they're limited by, is the factual allegations in the complaint that precede them. And those factual allegations are all about CNA. JA 48 has a great example of this. If we look at paragraphs 53 and 54, paragraph 53, I'll read it along here. I have it. I won't read word for word. But paragraph 53, for example, on JA 48, talks about how, according to Synopsys, RBS claims to be the owner of trade secrets contained in its VulnDB database. And so this paragraph is all about trade secrets in VulnDB. That's paragraph 53 on JA 48. And then paragraph 54 goes on to define what Synopsys believes is the case in controversy. And Synopsys says that it's whether Synopsys's conduct as a CNA, and then there's a long parenthetical explaining what that conduct is, constitutes trade secret misappropriation. And then Synopsys says CNA a few more times in that same paragraph. It says Synopsys has agreed to fulfill the duties of a CNA. Synopsys faces harm if RBS keeps saying that Synopsys actions as a CNA would misappropriate trade secrets. And so that's an example of where Synopsys defined the case in terms of this CNA activity. And so that defines the scope of the case. And the request for relief can't be any broader than that. That's the Clark case and all the other circuit court authority that we've cited in our brief. So that's why the covenant not to sue applies, and that's why this case never should have even reached summary judgment. Any trade secret issues belong in Massachusetts State Court at this point. But when the case did reach summary judgment, the district court should not have thrown out 75 out of 75 trade secrets as a matter of law, especially not on a fact-intensive issue like trade secret eligibility, especially not on a fact-intensive sub-issue like reasonable efforts to maintain secrecy based on just 2 NDAs out of hundreds of other NDAs and other secrecy measures, and especially not on a fact-intensive sub-issue like independent economic value in this declaratory judgment case where RBS did not need to specify the amount of the value of any particular trade secret. The district court also abused its discretion in excluding nearly all of RBS's
So
expert testimony.
what's your best evidence on the independent value of the trade secrets?
Some of the best evidence is what we highlighted the most in the briefing. We do have the RBS acquisition price. We've got expert testimony on value. We've got also, by the way, just the face of the documents
Well,
themselves.
what's the expert testimony on specific trade secrets?
The expert testifies about groups of trade secrets, and grouping makes a lot of sense here, by the way. First of all, it's permitted by law, as we've pointed out in the briefing, and Synopsys doesn't have anything that says it's not permitted by law. But second, in this case, trade secrets are naturally going to be grouped.
So tell us exactly where we're going to find this grouping testimony.
Sure, I can, it would be the Adam Shostak report, which is at JA 5861. That's the beginning of the report.
This part of Mr. Shostak's testimony that was permitted or excluded?
Our position is that it is permitted. What the district court held was that even though Mr. Shostak cannot testify as to conclusions about whether the elements of a trade secret were met, right? He can't say the independent economic value element is met. But what he can do, what the district court expressly said he could do, is he can testify about things like background of the software vulnerability industry, how people find vulnerability information. That testimony, even if all the other stuff were still excluded, which it shouldn't have been, that testimony would support a finding of independent economic value.
So where would we find testimony in the record that hypothetical trade secrets 1 through 10 have a specific value? Here's how we arrive at that value.
If the question, if here's how we arrived at that value is looking for a particular number, we don't have a particular number, but we don't need a particular number because independent economic value means competitive advantage. But if we're looking for competitive advantage, we've got...
What I'm looking for is a specific chunk of, even assuming you don't have to go trade secret by trade secret. But let's say you have a specific group, you identify the group. Where's the evidence that that group has a value, and how do you get to that value?
Great examples of that evidence would be in our opening brief when we walk through some example trade secrets, and many of those are grouped. And there we've got all kinds of citations to the record about those particular trade secrets.
Give us just one very specific one.
Sure. One specific one would be the trade secrets in files that Synopsys saved with file names that say high value in them. And by the way, that's not just some superficial statement of high value. That is, if you look at the document where Synopsys explains what high value is, and by the way, that's JA 4359, at that document, Synopsys defines what they think high value means, and it actually very closely mirrors the legal definition of a trade secret under federal and Virginia law. They say this is about important software vulnerabilities affecting software products that a lot of our customers used, and there's not a lot of information about this stuff elsewhere.
Mr. Samuels, but I think the question's begging, though, you had the burden of proof at summary judgment to rebut the allegation that you have no evidence on value. What I'm trying to hear you tell me is, where in the record do you answer that question beyond, you've said you've grouped it, but you've yet to tell me where you grouped it and what value you placed on the grouping. Where do we find that information?
That would be, Your Honor, where I would look to our opening brief when we go through those groups of trade secrets and we cite the evidence in the record supporting each of those trade secrets, where we describe, for example, Synopsys' own identification of these trade secrets as high value. We agree, by the way, that it was our burden to rebut their position that we have no evidence. But let's also clarify what their position that we have no evidence was in the district court. In the district court, in Synopsys' opening summary judgment brief, their position was the trade secrets are generally known, and therefore they have no value for not being generally known. In other words, they didn't have an independent argument about independent economic value.
Yeah, but doesn't that go to the second problem in your case, which is you didn't keep this information confidential?
Those are unrelated concepts, actually. So not generally known or readily ascertainable is one concept, and reasonable efforts to maintain secrecy is a different concept, a different element of a trade secret.
But I thought your response in front of the district court, your response to their argument was that we know the trade secrets have value because the database is the majority of the value of the company, right? And the company was sold for a significant price. That was the only argument to the district court about how we know the trade secrets have value.
That was the primary argument to the district court. Under Rule 56, the district court had to consider all cited evidence. There's no limitation on where that cited evidence has to be. We gave examples of our response to Synopsys' factual statement. That's right up front. That's the
Where did you tell the district court specifically, here's trade secrets 1 through 10, here's their value, and here's why they have value?
We did that in a couple of places. We did that in our opposition to summary judgment in the places that I mentioned, relying on our expert testimony, talking about the acquisition price, talking about the contents of the documents and what Synopsys did with them. We also did that in our opening summary judgment brief, which also should be considered because we're dealing with cross motions. In our opening summary judgment brief, we went through many of those groups of trade secrets as well. And by the way, what we did is...
You don't need to do it right now, but what might be helpful when you come up for rebuttal is to give us some specific pages.
Sure, happy to do that. And just to be clear, even just based on what we're saying right now, what we identified as evidence of independent economic value is completely consistent with other case law within this circuit. So in the Trandy's case, for example, out of this court, one of the trade secrets was object code in a software program. The software code had multiple trade secrets in it. Another one was source code, for example. But one of the particular trade secrets was object code. And after a trial, and then the Fourth Circuit affirmed the jury's verdict on this, after a trial, the court found that this object code had independent economic value because the trade secret owner used it in its business. It provided software services. It used the entire software. It was one of the things that the trade secret owner used in its business. And the trade secret owner made a lot of money from that business. And that object code could be used to provide similar services. And what this court didn't say is, where's the specific value of just the object code? You're telling me about all this money you made providing these services, in part with this program, which in part includes this object code. But it was still enough to find independent economic value. And by the way, the district court almost agreed with us on this. The district court almost got there. It acknowledged this Trandy's case. It acknowledged that we make most of our money from a specific service, a specific product. And then where the district court went wrong is it said, you have to show that a single trade secret could be used to create your whole business. And that's not right. Like the Pinchera case says, trade secrets can be parts of a larger system. Thank you.
All right, thank you very much. We'll now hear argument from Ms. Stetson.
Good morning, Your Honors, and may it please the Court. My name is Kate Stetson. I represent Synopsys. I'd like to start, Judge Rushing and Judge Agee, where the two of you started with the questions on mootness, because the mootness issue can be resolved one of three ways. The covenant that purported to be given to Synopsys was revocable, it was conditional, and it was also partial. So for RBS to prevail on its mootness argument, it has to establish that all three of those are wrong. And in answer to your first question, I think, Judge Rushing, what Mr. Samuel said was that it's unconditional and irrevocable because it says something about conclusively resolving the litigation. The way that you make a covenant unconditional and irrevocable is by saying, as Nike did in the Already case, I hereby unconditionally and irrevocably covenant not to sue you now or in the future for the instances of misappropriation that I alleged in my letter. They never said that. They never said that now, and they never said that below. So the fact that this was a revocable covenant should be enough to solve the mootness problem. You could stop there. It was also conditional, and that, I think, Judge Agee, was your question. This condition, such as it was dependent on that series of whereas clauses. And as we explain in our brief, one of the conditions was based on this particular so-called non-use representation, which was a term that RBS defined. They covenanted not to sue us for certain behavior. You know, that, as we also say in our brief, one of the concerns there is that RBS has done this before. In the Massachusetts case, there was an accusation in late 2017 about misappropriation of confidential information. Synopsys's employees represented in a series of declarations that the information had not been misappropriated, and RBS said, okay, in reliance on those declarations, we won't sue you. That lasted, not too much longer, I think, than this court will sit this morning, because a series of days or months later, Synopsys was found, or Black Duck was found to be the subject of an action based exactly on those so-called confidential information. So the fact that you have a revocable, conditional covenant, you could stop there. It was also partial for the reasons that you also discussed with Mr. Samuels. The issue in this case, under the cease and desist letter itself, the issue in this case involved purported misappropriation of trade secrets. It didn't say because of your role as a CNA. There were two separate cease and desist demands. One of them was cease and desist misappropriating our so-called trade secrets. The second was don't do that in your role as a CNA. So the covenant not to sue that we got, of course, was directed just to the role of the CNA and just to the VulnDB database. So it was partial. It's also partial because the purchaser of this particular company wasn't a party to that particular covenant not to sue either. So all three of those things that we've now covered, conditional, revocable, partial, mean that this case isn't moot. So turning to the merits, and I'd like to start, Judge Dawson, with your question about what this record shows, because I think what Mr. Samuel said at the beginning of his merits discussion was that the issue of independent economic value is a fact-intensive sub-issue in the case. The only reason that that issue becomes fact-intensive is if you have the facts in the record to make it a factual issue. And one of the problems that the district judge identified in this case, and again, these are two different grounds for summary judgment we're talking about, independent economic value and the failure to take reasonable efforts to maintain secrecy. Independent economic value was argued below to be shown by, Judge Rushing, your question, the purchase price of the company. And the idea that the district judge should have gone through what you all see now is a formidable record, searching for other hints of value, is something that is not supported by the cases. I would urge you actually to look at the cases that Mr. Samuel cites for this proposition.
What about the expert testimony, or the expert reports, I suppose? If we think hypothetically that the district court took a perhaps overly restrictive view of value and for that reason struck part of the expert report because the expert didn't individually value the trade secrets, would that change the result on the valuation? So in other words, if the district court excluded part of the expert's testimony about valuation, should that cause us to doubt the conclusion of granting summary judgment in your favor on that issue, or does it not make a difference?
I don't think it makes a difference, Judge Rushing. I think that there's a couple different strands of the valuation question. The reason the district judge concluded that there wasn't independent economic value shown is because, as Mr. Samuels argued today, the company was purchased in January of 2022 for a lot of money, QED. And what the district judge concluded was that you can't, I believe the word he used was perform some sort of illative process to conclude that the purchase price represents the value of VulnDB, which represents the value of some, but not all, of course, of the trade secrets alleged to be held within VulnDB. So you're already talking about this strangely tertiary valuation analysis that the RBS was asking the district judge to do. The question of the expert, though, with respect to Mr. Shostak, and I think that was the expert, of course, that the testimony wasn't completely excluded, as was the case with Kirsch. But with Shostak specifically said, I am not analyzing these trade secrets separately. That's the other person. But with respect to these groups, here are certain concepts that I find. But, when you have a trade secret...
I asked opposing counsel several times. I'll ask you, is there evidence in the record from Shostak or somebody else, some other expert, that gives an explanation of trade secrets 1 through 10? This is why they have value. This is how I arrived at their specific value as opposed to any other asset.
No, there's not. And the reason that Mr. Samuels identified 2 times in response to 2 of your questions, the opening brief in this case, I think tells you a great deal. This is a case that is, in response to the questions about where the evidence is, this is a fundamental failure of evidence. And the fact that Mr. Samuels is pointing to the opening brief here, the opening summary judgment brief below, all the lawyer arguments, I think tells you everything you need to know. I would encourage Mr. Samuels on rebuttal to look for and give you specific cites to specific value of specific trade secrets, because I'm confident that the cites to the record evidence do not exist to support that. And with respect to the second independent ground...
Before you go to your second one, let me just ask you one more question then about this independent economic value. It's not your position today that the trade secrets didn't have value. Is it your position, though, that they didn't provide evidence in the record to support what that value was?
Well, I think I'd actually pause on that first part of the question. I think you could argue, given the timing of the purchase of the company in January of 2022, when this litigation was at full sprint, when there was already summary judgment motions pending challenging whether these were even trade secrets at all, The fact that this company was purchased suggests that maybe these so-called trade secrets weren't the reason for the purchase at all. It was simply something that wasn't a trade secret. In order for a trade secret to have that independent economic value, we keep shorthanding it, but it needs to be independent economic value from the secrecy, from the trade secrets being actually kept secret. And I think the fact that this company was purchased without any kind of caveat or proviso about the fact that there was ongoing litigation, it was purchased at a time when all of these trade secrets were under serious challenge.
Well, when I asked Mr. Sanders, you said that the two issues don't really connect with each other, the whole secrecy component relative to value. What's your position to that? You're about to start talking about the second component.
Yes.
Are they connected or not?
They are connected. The reason that you look for independent economic value isn't just to say, does this particular document held by a company have some value? Does this particular arrangement of customer data have some value? You ask whether it has value from being kept secret. That's the Buffets versus Klinke case that I think we both cite in our briefs. And if it's not value from being kept secret, then it's not a trade secret under that particular prong of the trade secret test. The other independent prong of the trade secret test is, did this particular plaintiff, in this case, even though RBS is a declaratory judgment defendant, it was reformed as a plaintiff, does that plaintiff show a genuine issue of material fact that there were reasonable efforts taken to maintain secrecy? And again, when Synopsys put forward multiple agreements, not just two, but four agreements covering the time period that we're talking about, by the way, from 2012 through 2019. The time period at issue here is in the 2014 to mid-2017 range. Those agreements show, beyond serious cavil, that the information that RBS now says in 2018, 2022, 2023 should have been kept confidential wasn't kept confidential. And all of those agreements were met with an assertion.
Those agreements have some confidentiality provisions in them.
They did have some confidentiality provisions in them, but the holes in them, I think, are much more remarkable, because those provisions didn't extend, for example, to the use of VulnDB during the time of the license. They didn't extend to an end user. The end user was not required to maintain confidentiality of VulnDB's information in the reseller agreement itself that we're talking about.
Does that conclusively show, as a matter of law, that it would not have been reasonable for the owner of the trade secret to think that they had acted sufficiently to keep them secret? I guess the bottom line question is why is that not a jury question?
I think it's not a jury question, Your Honor, because when the district judge looked at what evidence had been mustered at this summary judgment stage, what he saw were a few agreements that were later in time. I want to say September 2018, October 2018, and one from 2019 that had confidentiality provisions. But what the judge also saw was a series of agreements covering this time period, the relevant time period, that had these holes in them, these end-user confidentiality lapses. And not just the agreements, by the way, but I think unrebutted is the fact that there were demonstrations that were done of this product. There were conferences at which the founders of RBS spoke about certain sources and data that they used in order to compile their methods of securing or of viewing insecurities within code. There were all sorts of early stage tryout periods, 30-day tryout periods that were completely devoid of any confidentiality provisions attached to them. And again, the idea that at some later time, not relevant to this case, RBS came into the knowledge, perhaps because it came into commercializing this product, that maybe it should keep its information more confidential is a little bit beside the point. So what the time period that we're concerned with, the evidence that was put forward, was simply not sufficient to generate a genuine issue of material fact as to reasonable efforts to keep something secret. And secrecy is a strange thing when you talk about a genuine issue of material fact, whether summary judgment should have been granted. Because once these things are out of the barn, once IBM has all of the VulnDB's trade secrets, once the other two companies that I think are still under seal have access to, and their end users have access to, all of VulnDB's trade secrets, once the reseller agreement in this case permits Black Duck to assign its rights and to give away to its customers the trade secrets of VulnDB, that's the end of the inquiry. The fact that there were other confidentiality agreements that purported to keep something confidential is a little bit beside the point. If there are any questions on the admission or the exclusion of the expert testimony, I'd be happy to answer them, or any other questions that the court has on mootness or on the two independent grounds for summary judgment.
Judge Wilson. Thank you very much.
Thank you, Your Honors.
All right. Mr. Samuels, you have some rebuttal time.
Thank you, Your Honor. A few more cites on independent economic value, record cites. JA 3975 is one. It's RBS's 30B6 witness testifying that the purchase price of RBS included the purchase price of the trade secrets. Also, again, the expert reports, for example, at JA 5887 through 5890. I'm again going to cite a summary judgment brief, not because I'm citing to attorney argument, but because I'm using it as a shorthand for all the evidence cited within it. That'd be ECF 341 at pages 25 and 26, where we walk through value as well. I'd like to revisit the mootness issue. Synopsys said there were 3 different arguments about why they believe this case is not moot. It all comes down to one argument. It comes down to whether these associated BDSA records are within the scope of the complaint. And they're not. And Synopsys didn't even try to cite the complaint. They cited our cease and desist letter, which is not a pleading. And our cease and desist letter, by the way, said, you're threatening to release this information as a CNA. And then it says, by the way, if you release this information as a CNA, it would give rise to all these claims. And so it's the release of information, which is what a CNA does. It publicly releases information. But again, that letter's not even actually part of the complaint. And to be clear, we talked a little bit about the already case on mootness. Already doesn't require any magic words for mootness. It doesn't require the word unconditional. It requires that you end any reasonable expectation of suit. And what Synopsys said to attempt to rebut that was to say, well, several years ago in Massachusetts, the parties had a dispute, and then they resolved it by amending the reseller agreement, and then RBS sued again. Well, that's not even a legally sufficient basis to avoid mootness. The already case says once bitten, twice shy is not a way to avoid mootness. But even besides that, that case never got to court. And in that case, the amended reseller agreement that ended the parties' dispute at the time included a page's worth of audit provisions because we weren't sure that they were going to keep complying with their obligations. So it was nothing like this case. So that's mootness. On independent economic value, I want to clarify one thing, which is the element of a trade secret that we're talking about here is independent economic value from not being generally known or readily ascertainable. And that is distinct from reasonable efforts to maintain secrecy. And the district court found a factual dispute about whether these trade secrets were or were not generally known or readily ascertainable. Then it decided as a matter of law that all 75 of these trade secrets had zero value from not being generally known or readily ascertainable. And I too would encourage the court to look back at the case law cited in these briefs on independent economic value. In particular, the MicroStrategy case that Synopsys cited all over the place to the district court and did here as well, and the case that the district court relied on in granting summary judgment. MicroStrategy, first I should mention, was an opinion after a bench trial, which again goes to show how fact-specific these issues are, like independent economic value. But then even after a bench trial, the court went back through all the trade secrets, and here are the types of findings it made about the independent economic value of the trade secrets. There was a technical document that was one of the trade secrets, and the district court said the independent economic value of this document is obvious because it would be hard to recreate on your own. Obvious. And then elsewhere in that opinion, the district court in MicroStrategy says the independent economic value of a business strategy document is clear because if it got out, you could use it to compete against the trade secret holder. That's what we're getting at with independent economic value, not these particularized showings. What we're getting at is a competitive advantage, and would the information lose value if it got out? And by the way, Chimura is another case that shows an example of this. Chimura determines independent economic value on the face of the trade secret document. Actually not determines independent economic value, but finds a factual dispute of value just based on the face of the document. And so that's what independent economic value is about. As far as reasonable efforts to maintain secrecy, we got into a discussion there on the other side about purported holes in the agreement and what we think this agreement or that agreement means. That's not a summary judgment argument. And it's a factual issue. Again, Synopsys reiterated this idea that they say it in the brief too. They go, well, the horse is out of the barn. Another problem with their secrecy position is that they don't tell us where the horse is. They don't have evidence of us actually disclosing those trade secrets. So I'll leave with that. And again, just to reiterate on independent economic value, I gave you those sites, but I want to be clear. You'll see in those sites that Mr. Shostak grouped RBS's trade secrets and analyzed their value in groups. Thank you.
Thank you very much. We'll come down and greet council and then take a very short recess.
Sorry. Sorry. Yeah, sorry about that. Very nice to meet you. Thank you very much. Thank you so much. Thank you. We enjoyed your argument yesterday, too.
Powers Watson versus National Union Fire Insurance Company. Mr. Hacker.
Good morning, Your Honors, and may it please the Court. John Hacker for the appellants. As the recent decisions in Komatsu and Onyx explain, bump-up clause in a liability policy for directors and officers exists to ensure that insurance proceeds do not become an additional source of funding for inadequately priced corporate deals. To avoid that outcome, the clause here addresses lawsuits alleging that, quote, the price or consideration paid for the acquisition of all or substantially all the ownership interest in or assets of an entity is inadequate. Under the clause, when a lawsuit makes such an allegation, the policy will cover the defense, but it will not cover, quote, any amount of the judgment or settlement representing the amount by which such price or consideration is effectively increased. The district court here rejected application of that plain language because in the court's view, an acquisition under the clause refers narrowly only to transactions where both parties survive and excludes mergers where one party no longer survives, which in the court's view is what happened here. That's wrong, Your Honors, for basically two reasons. First, nothing in the bump-up clause is dependent on the survival of either entity. If one entity merges with another into another and just disappears, the eliminated entity, of course, was acquired by any understanding of that term. As that example shows, there's no merit to the district court's focus on acquisition as a narrow term of art requiring that a party survive. Second, Towers Watson, in any event, did survive the transaction that was relevant here, which is the transaction that was challenged in the underlying suits. For both reasons, while one can accurately describe the transaction here as resulting in a merger, it was a merger executed as an acquisition, which in turn triggered a lawsuit by Towers Watson shareholders complaining that they were forced to relinquish their shares for inadequate consideration. Put slightly differently, Your Honors, we know that the ownership interest in Towers Watson was acquired because shareholders complained about the inadequate consideration they received when they were forced to relinquish that ownership. Let me start with the controlling documents in the transaction, which both control what the relevant transaction is and help explain why this is an acquisition of the ownership interest in or assets of an entity. Now, we know it's structured as a reverse triangular merger, and all authorities from this court and elsewhere recognize a reverse triangular merger as an acquisition. The proxy statement and associated documents are completely explicit about this. They say that Willis was the acquiring entity, that's at JA 536, that Towers Watson would be surviving as a subsidiary of Willis, that's at JA 496 and 501. Now a reverse triangular merger exists when the acquiring subsidiary merges into the acquired entity and leaves the target existing. It's different from a forward merger where the merging entity, where the acquiring entity, the acquired entity just merges into and disappears. In this case, the subsidiary, in any reverse triangular merger, the subsidiary of Willis is created Citadel. It merges into Towers Watson, and by so doing, sort of pulls Towers Watson into and under Willis, leaving Towers Watson as the surviving subsidiary. That's the relevant transaction. The district court and Towers Watson incorrectly focus on the second part of the overall deal, which is an internal reorganization, which wasn't relevant to the shareholder lawsuits that are at issue.
Can I ask you a technical question that, I'll preface my question with, I don't think this necessarily matters for the outcome, all right, for the heart of your case. But I want to make sure I'm understanding these transactions correctly. Is it correct to say that when Willis acquires the ownership interest in Towers Watson, because we have the reverse triangular merger, Towers Watson becomes a subsidiary, Willis, per the transaction documents, then holds all the outstanding shares of Towers Watson. The assets of Towers Watson are still owned by Towers Watson. They're not acquired. The assets are not acquired by Willis at that point. The assets are acquired by Willis later when Towers Watson merges into a different Willis subsidiary.
So that's absolutely correct with one addition, caveat.
It's not correct to some extent. How is it not correct?
Point that what a qualified stock purchase is.
Yes.
What that is entitles the taxpayer to treat what would be a stock transfer, which a stock exchange, a stock
Right.
purchase, as an asset purchase for tax purposes.
Yes, okay.
It's actually sort of, it is a matter of law, it's both. It's a matter of tax law, it's both. Now, they say they didn't make that election, and that's fine.
The ownership interest allows you to treat it as though you own those assets.
For tax purposes.
For tax
right,
purposes.
For tax purposes, right. And they say they didn't make that election. That's completely irrelevant that they didn't make the election.
But after the second part of the transaction, where Towers Watson merged into another subsidiary and kind of ceased to exist, its assets were then, in all senses, acquired by the Willis entity.
Right, which is one of the errors in the court makes in focusing on the fact that Towers Watson is eliminated in the second phase of the transaction, the internal reorganization. As I say, first of all, survival is just irrelevant under the plain text of the bump up clause. But also, even if you think that somehow matters, at the end of the day, Towers Watson owned all of its own assets on day one, and on day two, or day 3 or 4, after the whole deal is complete, Towers Watson doesn't own any of the assets anymore. A new entity, Willis, owns them. And because of the internal consolidation, which you're going to hear a lot about, the former Towers Watson shareholders are 49.9% shareholders of this new entity, but the assets are now owned by Willis. There's a sale of substantially all or substantially all of the assets if you look at the transactions together. And we submit, of course, the first error is even looking at that second transaction, because the second transaction, Your Honors, wasn't relevant to the shareholder lawsuits that triggered coverage as a securities claim under the provision, under the policy, right? The policy is here. We're only talking about coverage because shareholders said, in this transaction, no matter how you look at it, in this transaction, our shares were relinquished for inadequate consideration. Somebody else acquired the shares. Who was the somebody? It was Willis. And they acquired all the shares. And the shareholders said they didn't get adequate consideration. The plain language of the bump up clause says in those circumstances, the policy will pay for the defense, absolutely, and we did pay for the defense, but we won't pay for that portion of any judgment or settlement of that claim for inadequate consideration that represents an effective increase in the consideration.
I'm sorry, go ahead.
Mr. Hacker, but isn't Ms. Cohen going to get up and say that's not what happened? There wasn't an effective increase, and that's not the basis for our claim. If in fact she gets up and says that, my fundamental problem is it sounds like we disagree on the facts. And if we do, how is summary judgment appropriate?
Well, so first of all, we think you can reach it as a matter of law. They moved for summary judgment on that. I agree with that.
I understand it, but isn't this brought to us as the result of a cross motion for summary judgment where both parties said there are no disputed facts? We believe this should be decided as a matter of law, and then I'm left with trying to figure out which one of you I believe.
I think functionally, that's where we are, just to be clear about the procedure. What we said in response to their summary judgment, we did not file something denoted a cross motion for summary judgment, at least it's not my understanding. What we said in response was under Rule 56F, because the facts are clear, you can grant motion independent of a judgment independent of the motion.
Sure. So you're going to now tell me.
And so now let me try to explain to you why I think it can be resolved as a matter of law. To the extent you think there are facts in dispute, we agree that a remand would be required. That is, that would be acceptable because we think we'll just show very easily to the district court what I'm about to explain to you, which is that the settlements unambiguously represented an effective increase in the consideration for multiple reasons. Start with the settlements themselves, what they say. The settlements themselves provide consideration, the money that's paid, the $15 million for the Delaware action and the $75 million for the Virginia action, when they're explained to the judgment in the fairness documents, explained to the court in the fairness documents, they're prorated by shares. They're pegged to shares and the amount of shares that each shareholder has. And in the Onyx case, the court emphasized that as a way of identifying that whatever else may be true, and there's other things I'm going to talk about, but whatever else may be true, when the payment says this is how much on a per share basis each of you is getting, that is on its face an effective increase in the consideration, the per share consideration they got.
The
for the deal.
settlements themselves, and they wouldn't be required to, don't say the exchange price was X, you should have gotten X plus Y, the difference is Z, that's what you're going to get on a per share basis.
So, and precisely because of the first part of your question, which is they wouldn't be required to, they don't say that in those terms, but that's also why the bump up clause says it has to represent an effective increase in consideration. You just have to look at the facts and identify whether or not what they got was an effective increase in the consideration.
But isn't that what we have to figure out, is whether or not it was in fact an effective increase? And how do we get there?
So the first place is by just reading the settlements, I think. That's what the Onyx Court said, which I believe was on summary judgment. The settlements tell you that this is per share, this is the amount you got before, you're getting more now on a per share basis. That's one fact. The other fact is what the complaints were seeking, which was entirely inadequate consideration. That was.
But don't you disagree on that point as well?
I don't think so. They may say that they disagree, but you can read the complaints. You can't disagree with what the complaints say. What the complaints allege and seek is inadequate, is additional compensation.
But in the record, doesn't the trial judge ask the parties to submit their positions relative to the effect of the settlement and what you believe the damages or the inadequacies are? And the parties don't issue a joint document in that regard, do they? And in fact, you submit separate documents arguing in different directions.
Right, but in any summary judgment, that's true, right? Parties argue different things, and they will sometimes insist that they have different views of the facts, but the facts are what they are. And the facts here are what the settlements say, what the complaints allege, which is that we did not get paid enough. That's why they're complaining. What the expert report says, that's what you're going to hear from Ms. Cohen, I'm sure, that the expert report, the experts didn't allege a theory of that they should have received increased compensation. That's just not true. When you read the expert reports, the particular one, the Virginia case, the only one that's even relevant here, they didn't complain, they didn't make this argument with respect to Delaware. With respect to the Virginia expert absolutely does a theory of underpayment for stock. What she points to, what she's talking about, is and this is what the district court described, I think in a footnote, or no, early in the opinion. What the district court says is part of one of the theories, several different damages theories, one of the theories that Towers-Watson points to is a change in stock value, right? Before the Towers-Watson, before the deal is announced, Towers-Watson stock was at, X. The deal gets announced, it goes down to X minus 10, he says. And he says if the conflict had been disclosed, it would have jumped back up to X. So that 10 delta is a difference in stock value. And they say that's not a claim for inadequate consideration. That's not true. The expert says to the contrary. If you look at page 348 of the joint appendix, when he's explaining the theory, he says this is just another way of explaining, of showing the compensation they should have received. When their stock went from X to minus 10, the minus 10 delta, that's the amount that they should have been compensated in Willis stock. That's another way of getting at the amount they should have been compensated. He explicitly says this is their out-of-pocket loss. An out-of-pocket loss is another way of saying I didn't get compensation. If I gave up my stock for an insufficient amount and lost, that minus 10 or whatever other ways there are of getting at. None of those facts, Your Honor, are disputed. And so that's why I think you could resolve this as a matter of law at this stage. I accept that if you think, these arguments should be heard in the first instance by the district court, I understand that. One could say that. The one thing you cannot do, I think, on the facts I've just discussed, is affirm judgment for Towers-Watson on the theory that, as they argue, as a matter of law, this is their argument as a matter of law, this is not an effective increase in consideration. And there's absolutely no way to get to that result, Your Honors. If there are no further questions on that or the other issue or the primary issue, I'm happy to see the balance of my time.
I have one inquiry which probably does not go to the merits, but just so I'm sure. So when Citadel merged into Towers-Watson, what was the status of the stock ownership of Towers-Watson at that point?
Well, I'm not going to understand. What do you mean the status of the ownership? I mean, that
Who owned the stock of Thomas?
The same shareholders would have owned it.
So the Pre-merger, Towers Watson stockholders were unchanged when Citadel merged into Towers Watson.
I'm only hesitating because the precise timing. There was part of the transaction, there was the merger into, but part of the transaction that included, right, the exchange. Towers Watson shareholders gave up each of their shares for a certain amount of Willis shares. I think that happened after. I'm virtually certain that happened after, it may have been now.
Right, yeah,
After the merger into, and then, so what happens is there's a merger that pulls Towers Watson, that becomes a subsidiary, a wholly owned subsidiary of Towers Watson, of Willis, the shares are exchanged.
So they're sequential steps, even if they're only momentary, but they are sequential.
I don't want to swear to you that they're sequential in that way, but what does happen, of course, is that you end up with both the stock exchange and then the reverse stock split, which consolidates shares, so that you end up with the 49.9% and 50.1% shared ownership.
All right.
Thank you.
Thank you. You've got some rebuttal time. I do note that when the case arose for interpretation of an insurance contract, we lost our audience. So with that, we'll hear from you, Ms. Cohen.
I'm sure it wasn't the insurance aspects, it was the corporate law aspects that must have.
Good morning, Your Honors. May it please the Court, I'm Robin Cohen on behalf of Willis Towers Watson. The district court got it correct when it found that these insurance companies did not meet their high burden in establishing that the stock-for-stock merger constituted unequivocally and clearly an acquisition as that term is used in the policy. Fundamental problem with the carrier's analysis is they are looking at it as an esoteric corporate issue as opposed to looking at it by the fact that this is exclusionary language in the policy, and they must demonstrate that this transaction clearly and unequivocally was an acquisition as used in the policy, and that our interpretation is not equally possible. Unlike the cases that Mr. Hacker mentioned, like the Onyx case and the Ceradyne case, those were cash buyout deals. Here, it is undisputed, as shown in the proxy statement, you had two companies of relatively equal size merged and combined into a new company, and unlike those cases, Towers Watson didn't walk away with cash. They became co-owners of a new business with virtually equal ownership and equal control. In fact, the board of the new company consisted of 6 former Tower Watson directors and 6 former Willis directors.
Why does that make a difference?
Because you're looking at it from the perspective of an ordinary person and how they would view the transaction. If everything is equal ownership, equal control, the fact that the
Tower... There wasn't, there were, as I understand the record, the Willis stockholders ended up with a majority.
Well, Your Honor, to your question, they did 50.1%. And we would suggest that 50.1% of the new business does not constitute all or substantially all of the ownership interest in or assets of.
Can I ask you about that? After the transaction, who possessed all of the outstanding shares of Towers Watson?
There was no longer any shares, and this goes to Judge Agee's question.
So that's key. So you're thinking, when I say after the transaction, you're thinking kind of both steps.
Yes.
So after the transaction then, who possessed all the assets of Towers Watson?
Towers Watson disappeared.
Right, but its assets didn't, right? They didn't evaporate. They weren't nuked. Where did their assets go? Who owned them? Who possessed them after the transaction?
The Willis subsidiary. Because what happened, and this is to
So Willis,
not Willis, the Willis subsidiary. So what happened here is that, and I think this is
so if the Willis subsidiary has all of the assets of Towers Watson, it had to get to them somehow. And another word for get is acquire. It had to acquire them.
So Willis never acquired any of the stock and any of the assets. The proxy statement is very clear. With respect to the stock, the Towers Watson stock was canceled and delisted, and the Tower Watson shareholders received by operation of law the newly issued Willis shares. So Willis never bought any of...
I thought that transaction document said that the surviving entity, which was Towers Watson, yes, it was delisted, and then it had to issue new shares, which were all held by Willis.
Yes, but the shares that were owned by the Tower Watson shareholders were delisted and canceled. That's JA 510 and JA 536. So Willis never acquired any of the Tower Watson shares that Towers Watson shareholders owned. You are correct, Your Honor, at JA 758. At a certain point, Towers Watson issued new shares that the Tower Watson shareholders never owned, and those shares almost immediately went into the Willis subsidiary. And so it's...
Who owns the Willis subsidiary?
WTW, it was Willis, and they did a name change to Willis Towers Watson. And so Willis Towers Watson, Your Honor, owns the Willis subsidiary that is WTW Delaware Holdings. But for purposes of this policy, as the district court found and is supported by
So at least through the subsidiary, this parent corporation does own all of the prior assets of Towers Watson.
Well, Your Honor, Towers Watson, when it merged into Citadel, and then it disappeared that day into the subsidiary, so the subsidiary, to the extent Towers Watson still exists, would be in the subsidiary. It's not in WTW, which is the parent.
Right, but the parent owns the sub, and the sub owns all of the assets that previously were in Towers Watson.
Yes, yes.
So how does that affect this case?
Because you have to show that that Willis actually bought the assets. They have to buy all or substantially all of the assets.
That's not the terms of the policy.
I'm sorry, Your Honor?
Acquired.
It's acquire all or substantially all of the assets. And the question of what does acquire mean? To an ordinary
If the parent owns the sub, and the sub owns all the assets, hasn't the parent acquired, even though it's not directly, all the assets of Towers Watson?
No, Your Honor, because Willis never bought any of the assets. As the district court found, it was a stock-for-stock merger.
But at the end of the day, they still control them all. So I'm having difficulty understanding the value of the distinction you want to draw.
Okay. So the difference is, what would an ordinary reasonable person think when they see the words acquire all or substantially all? No one disputes that at most Willis acquired 50.1% of the stock. That clearly, or I think reasonably, would not be all or substantially all of the stock. With respect to the assets, that language, all or substantially all, comes right out of the Delaware Code, and that is an asset sale. And even the defendants would concede that this is not an asset sale. So whether you look at the fact that Willis never bought the stock, or this is not an asset sale, our position we submit would be reasonable based upon an ordinary person.
Well, why wouldn't that reasonable, ordinary person look at this and see that even though it goes in a corporate train that the parent corporation can do whatever it wants to with all of these assets. It just seems like to me it would be hard for this hypothetical ordinary person not to see that transaction as an acquisition of all the assets.
Because, Your Honor, what we believe an ordinary person would look at is you have two companies of relatively equal size. They merge into a new company. The Tower Watson shareholders don't walk away with cash as they did in the other cases. They become equal owners and have equal control of the new business. It's difficult to envision a situation that is more like a merger than this particular situation. You would have to, and especially given the language in the policy that talks about all or substantially all, they can't get away with from the fact that the new company Willis only had 50.1% of the stock. Under any, reasonable way of looking at that, that's not all or substantially all. And with respect to the assets, that's a term of art under Delaware law. And this was not an asset sale. It was exactly the opposite of an asset sale.
It seems, I had this impression reading the briefs as well. It seems like you kind of have to choose if you're going to say the reasonable, ordinary person who doesn't know much about corporate law principles and doesn't read the deal documents, they would look at this and say, yeah, it looks like two equals merged. You kind of have to choose if that's your theory or if your theory is this is a highly specialized term of art where acquisition of all or substantially all of the assets is understood to mean an asset purchase that necessarily excludes mergers as defined in Delaware law.
Judge Rushing, let me address that point, because let me start with the ordinary reasonable person. They're going to look at the policy, and then they're going to look at the proxy statement, which they say is the controlling document. That proxy statement describes this transaction as a merger over 1,600 times. And the only time the word acquirer is mentioned at all is in the context of the accounting treatment. And even in that technical accounting treatment, it says in the proxy statement that although we are a merger of equals, for purposes of accounting treatment, we have to choose an acquirer and an acquiree. So a reasonable ordinary person looking at the documents would say it screams we are a merger, and even in the tax treatment, it expressly says, although we are a merger, we have to do this for technical reasons.
That argument assumes that acquisition of all or substantially all the assets or ownership interests excludes all mergers, right? Which it just doesn't as a matter of corporate law, right?
Well, Your Honor, the mergers and acquisitions are distinguished under the policies. And a reasonable ordinary person would look at the policy and look at these documents, including the proxy statement, the merger agreement, and the SEC filings, and come to the conclusion that this was the reverse of a merger. Reverse of an acquisition. This was a merger. The language all or substantially all, as a Northrop judge found, that's a takeover. It's a difficult proposition to suggest when the Tower Watson shareholders had equal control and equal ownership and didn't walk away with cash but became part of the business, that's a takeover.
So why would an insurance company write an exclusion provision like we have here to carry the meaning that you offer? It doesn't seem to make any sense to me obviously if they wrote it, it has to be construed in the insured's favor and all that sort of stuff, but it just doesn't make sense to me that the exclusion would have been written to have that impact.
Your Honor, we would disagree for this reason. The policy is designed to cover alleged wrongful conduct in a securities situation. This sort of case where there's lawsuits after a merger is very common. And so the grant of coverage is very, very broad. So if you want to take away that coverage, you have to do it clearly and unambiguously. And what the district court found, that in this case, they did it very narrowly. They said, if you are this particular type of transaction, which is a takeover, then we are potentially going to take away that coverage. So what we submit, Your Honor, it's very consistent with the policy. We also disagree with counsel. If the purpose of the exclusion, which there is nothing in the record to suggest this, but if the purpose is to make sure the policyholder, which is Towers Watson, make sure they don't fill in the gap and use the coverage because they bought something that was too cheap, that doesn't serve the purpose here, because Towers Watson isn't being alleged to have bought Willis cheaply. It's the other way around. It is Willis that is being accused of buying Towers Watson cheaply. So even if we were to go and...
The other way of saying that is that Towers Watson sold out too cheap.
But that was not what counsel was suggesting was the purpose of it. They were suggesting that it was a situation where a policyholder was attempting to buy something too cheaply and using the coverage. It doesn't serve that purpose. The other thing I would note, Your Honor, is the cases that they cite to, like Onyx and Ceradyne and Komatsu. All of those cases underscored why we're correct. In all of those cases, the court made it clear that our situation, which was a merger, is different than their situation that were clear acquisitions where the comparable Tower Watson shareholders walked away with cash. If I may address the increase in consideration argument at this point. You were correct, Judge Dawson. There were, both sides filed motions for summary judgment on the issue. And it is undisputed that when you look at the issue of whether this was a loss, that the loss represents an increase in consideration, you have to look at the assumed liability at the time of the settlement. And those are the facts. And we, meaning the underlying plaintiff, proffered the primary theory, which was upon disclosure, the shareholders would have voted down the deal and they wanted their stock to be reverted back pre-merger. So this is not a bump up theory, it's a bump down theory. And the reason is the theory is based upon the assumption that the merger never happened. Upon disclosure of the conflict of interest, there would be no merger. If there's no merger, then there's no consideration. And if there's no consideration, there's no increase in consideration. Now, that report by Mr. DeBack is 16 pages long. And at the very end, he does suggest, as a reasonable check, there's also potentially this other theory, this hypothetical renegotiation. As the district court found, that theory was never quantified. It's likely not valid under Fourth Circuit law. And so the only theory that was actually quantified and is actually potentially viable was a bump down theory.
Why does that matter for purposes of this policy when the policy talks about representing the amount by which such consideration is effectively increased, right? The effectively and representing seem to suggest that we look at reality, what really happened, right? We can't go back and undo the transaction. So the shareholders got X amount. After the settlement, they have now gotten Y, right? The X plus Y. And why aren't we just looking at that reality kind of regardless of what an expert called it, especially in a settlement where it's a negotiation. It's not necessarily calculated based on an expert's testimony?
Because, Your Honor, the adequacy of the consideration has no bearing on the settlement because it's based upon the theory that no merger took place.
But in reality, they got more consideration, right? That no matter kind of what the theory was, they got more, the settlement gave them more consideration for their shares than they had previously received.
I would disagree with that premise, Your Honor. They didn't get an increase in consideration. What they did was they got reverted back to what the price would have been if there's no merger. The theory that was put forth by the expert is a retroactive theory, putting you back into the position as if the merger never happened is very different than a hypothetical renegotiation based upon intrinsic value, which the Fourth Circuit does not even recognize. So the theory, unlike the cases that they cite, like Komatsu, there are two prongs to the exclusion. And the second prong says that the loss has to represent an increase in consideration. And that the only theory that was put forth is not an increase in consideration. Moreover, the
An
attorney...
effective increase in consideration.
Effective increase, but Your Honor, we would submit it's not an effective increase in consideration. In fact, it's not even a viable theory under Fourth Circuit law. Second, the attorney's fees that were part of the settlement, that was not an increase in consideration to the shareholders.
Anything else, Ms. Cohen?
Thank you, Your Honor.
All right, thank you very much. Mr. Hacker, you have some rebuttal time.
Thank you, Your Honors. I'll just start where Ms. Cohen ended on effective consideration and just make a couple quick points. First of all, as I already explained, that theory was a measure of the difference in the stock drop, but at JA 348, you'll see the expert saying that's a way of measuring out-of-pocket loss. That difference tells you the amount they should have received. That's when the difference between the value of their shares and the value of the Willis shares was that amount, and that's just a way of measuring it. That's what he says. Even more importantly, plaintiff's counsel told the court what the theory was at the class certification hearing, and counsel told the court that their theory was one for having received inadequate...
This is in the Virginia case or the other case?
In the Virginia case. Class certification, counsel said, that's what we're complaining about, inadequate consideration. And finally, I would make the same point that the Onyx Court and I believe Ceradine Courts made, which is that the party paying is now paying the consideration, paying the amount, paying the settlement is Willis. So it represents an effective consideration for what Willis obtained. The ownership interest and assets of, or the Willis subsidiary obtained, if you want to look at it that way, the ownership interest in the former Towers Watson, the assets of the former Towers Watson. Willis is now paying more for that as a result of the settlement. It's a classic representation of an effective increase in consideration. I also want to go back to the question Judge Agee asked, which I don't think was correctly or really answered at all, which is why would an insurance company write an exclusion that draws this narrow, I would say artificial distinction between mergers and acquisitions? They wouldn't. There's no reason on earth an insurance company would do that. What they tried to do is what they said, which is to exclude claims claiming inadequate consideration for the acquisition of all or substantially all the ownership interest in or assets of an entity. It's the plainest possible language. There may be some disputes over what an asset is it intellectual property, or what constitutes ownership interest in, but stepping back, it could not be clearer that it encompasses this kind of transaction. It's trying to escape esoteric distinctions between a merger or a takeover acquisition or a corporate acquisition. It's using acquisition exactly as Judge Rushing said, as a synonym for to get or obtain, to acquire these things. If we're going to have discussions about corporate law niceties, it may be about what constitutes an ownership interest in, or maybe what constitutes an asset. But acquisition is the easy part. That's just you're getting those things. And then you have to figure out in the transaction, did an entity obtain, acquire ownership interest in or assets of substantially all ownership interest in or assets of an entity? And that's what happened here. There's not a distinction at all, as Onyx and Ceradine and the plain language say, between who the acquirer is, whether it does not apply only to assets that are or ownership interest when Towers Watson acquires an entity, right? It's this case. It absolutely encompasses this case exactly as Judge Agee said. When the complaint is from Towers Watson shareholders, you gave up our shares. You allowed somebody else to acquire ownership interest, i.e. our shares, for an inadequate amount. When that happens, the bump up clause by its terms and by its purpose is triggered because that is a claim that creates this moral hazard where the Towers Watson management, could do what it did here, which is negotiate a deal for too little. Somebody complains, and the management says, they negotiate a deal for too little, knowing somebody probably will complain, and that's fine because insurance will cover it. That's the moral hazard that applies exactly in this case. This case, indeed, I think, exemplifies it. It doesn't matter, Your Honors, that at the end of the day there was 50.1%, 49.9%, as Judge Agee pointed out. Willis shareholders ended up with a majority, but that's not even the relevant inquiry. The relevant inquiry is earlier, as I think Judge Rushing was getting at with questions to me and to Ms. Cohen, that what you had was Towers Watson having ownership interest shares and assets. The question is, did an entity acquire the ownership interest and shares? It doesn't matter, Your Honors, I think, whether or not it was a subsidiary of Willis, and not just because, for the reason Judge Agee was saying, is a functional matter, the parent owns and controls the subsidiary's assets, but under the plain terms of the bump-up clause, a Willis subsidiary is an entity. A Willis subsidiary acquired substantially all of the ownership interest in and assets of Towers Watson, even if, no matter how they were later divided, the ownership interest, the shares. It doesn't matter that they were delisted. It doesn't say shares. It doesn't say acquire the shares. It says acquire the ownership interest. Willis acquired all of the ownership interest. The Willis subsidiary did. The Willis subsidiary acquired all of the assets, and that's the end of the inquiry. Thank you, Your Honors.
Thank you very much. I appreciate the argument of counsel. I will ask the clerk to adjourn court until tomorrow morning, and we'll come down and greet counsel.